Hi everyone, my name is Shazia Khan and I am the Head of Law for UK Varsity. I have been teaching law on undergraduate programmes and postgraduate programmes for the last 16 years at a variety of different institutions. I have a range of experience practicing law and dealing with client cases and representing clients at court. I've got a degree in international law and a master's in European law, and also have a PGCE in education. We will now be looking at the unit which is 3.27, which is the English legal system. And we will be looking at the module specification and look at the key terminology. And we'll also be looking today at learning outcome 1, which is to understand the key principles of English law. So I'll just start off with looking at the module specification, which is looking at the unit aims, which is to provide an overview of the English legal system and to prepare the learners for substantive study in areas of English law. It's a level 3 unit, 15 credit value, and you could get a pass, merit or distinction in doing this when doing this assignment. And each learning outcome identifies what you need to do to get a pass, merit or distinction. So the first learning outcome is to understand the key principles of English law. Learning outcome 2 is to understand the rules of statutory interpretation. Number 3 is to know the organisation work of the English courts. Number 4 learning outcome is to understand the operation of judicial precedent. And what we'll be looking at in regards to this is identifying the key concepts and the terminology around this in regards to trying to meet the learning outcomes in regards to the criteria. Today we'll be looking at learning outcome 1, which is to understand the key principles of English law. So now I'm just going to bring the slides up for you. So this is 3.27, the English legal system, and learning outcome 1, to understand the principles of English law. So the learning outcomes is to explain the different methods by which laws are made, differentiate between criminal and civil law, differentiate between public and private law. So 1.1 is to explain the different methods by which laws are made. We're going to look at the stages in English lawmaking. So firstly, we look at the different laws made in the UK and who passes the laws and who makes the laws. So Parliament is a body with the highest legislative authority in the United Kingdom. It checks and examines the work of the government. Parliament also debate and approves new laws, which we're going to go through so you'll realise, proposed by the government. The House of Commons, elected MPs and the House of Lords together make Parliament. A bill can only become an act of Parliament when the House of Lords and MPs both vote to support it. The House of Lords have the power to reject a bill and was limited by the Act of Parliament 1911 and 1949. A bill can still become a law if rejected by the Lords, provided it is reintroduced into the House of Lords. So these are the stages. So you have the introduction stage, where a bill is introduced by the government or an MP. Then you'd have the first reading, where it is brief and just an introduction. Second reading is the most important, as it's the first opportunity to debate the contents of the bill. Then the committee stage involves detailed examination of the bill, following any sort of amendments or anything. Report stage is once the committee has finished the scrutiny of the bill, it reports back to the Houses for another debate. Then the third stage is the reading, the final chance to debate the bill, and is restricted as its actual contents rather than what should have been included. Then they would have the first reading in the House of Commons, second reading, committee stage, report stage, third reading, and then it would receive royal assents once both parties have approved the bill. So we'll go through the stages. Bill starting in the House of Commons. So bill starting there. So as we mentioned earlier, in the House of Commons, first reading, second reading, committee stage, report, stage, third reading, then the House of Lords, first reading, second reading, committee stage, report stage, third reading, and consideration of any sort of amendments, and the royal assent. So a bill is a proposal for a new law or proposal to change an existing law presented for debate before Parliament. A bill can start in the Commons or the Lords and must be approved in the same form by both houses before becoming an act, which is a law. The government in the UK introduces a great majority of acts of Parliament, Parliamentary Council to Treasury first by instructions, drafts what should be included in the proposed law and its effects, impacts on society, and this is known as a bill. So the stages in lawmaking. So the stages involved in lawmaking in the English law system includes a bill, which is a first reading. And in this, the first reading is the first stage of the bill's passage through the House of Commons. Usually a formality, it takes place without a debate. First reading of a bill can take place at any time in parliamentary session. The short title of the bill is read out and is followed by an order for the bill to be printed. The bill is published as a House of Commons paper for the first time, and then the next stage, as we mentioned, is the second reading, the first opportunity for MPs to debate the general principles and themes of the bill. So the second reading. So these are bills that start in House of Commons, so second reading. Second reading is the first opportunity for MPs to debate the main principles of the bill. So if there's any sort of issues around the bill or any sort of the requirements that need to be put in the bill at this stage, it's where they will look at any sort of issues regarding that. It usually takes place no sooner than 2 weekends after the first reading. The government minister, spokesman or MP responsible for the bill opens the second reading debate. The official opposition spokesperson responds with their views on the bill. The debate continues with other opposition parties and backbench MPs giving their opinions. At the end of the debate, the Commons decides whether the bill should be given its second reading by voting, meaning it can proceed to the next stage. It is possible for a bill to have a second reading with no debate as long as MPs agree to its progress. Once second reading is complete, the bill proceeds to committee stage, where each clause, which is part of the bill, and any amendments which are proposals for change to the bill may be debated. We've got the committee stage at the House of Commons now, which is the committee stage is where detailed examination of the bill takes place. It usually starts within a couple of weeks of a bill's second reading, although this is not guaranteed. Government bills are usually formally timetabled after they have received a second reading. Most bills are dealt with in a public bill committee. If the bill starts in the Commons, the committee is able to take evidence from experts and interest groups from outside Parliament. Amendments, any proposals for change for discussion are selected by the chairman of the committee, and only members of the committee can vote on amendments during the committee stage. Amendments proposed by MPs to the bill will be published daily and reprinted as a marshalled list of amendments for each day the committee discusses the bill. So committee stage continued. Every clause in the bill is agreed to, changed or removed from the bill, although this may happen particularly under a programme order without debate. A minority of bills are dealt with by a committee of the whole House, takes place on the floor of the House of Commons, with every MP able to take part. The selection and grouping of amendments in a committee of the whole House is decided by the chairman of Ways and Means, which is the deputy speaker. Bills fast-tracked through the House of Commons will receive less consideration. Consolidated fund bills do not have a committee stage at all. If the bill has been amended, the bill is reprinted before its next stage. Once committee stage is finished, the bill returns to the floor of the House of Commons for its report stage, where the amended bill can be debated and further amendments made. So the report stage. The report stage gives MPs an opportunity on the floor of the House to consider further amendments, any proposals for change. to a bill which has been examined in the committee. There is no set time period between the end of the committee stage and the start of the report stage. All MPs may speak and vote for lengthy or complex bills. The debates may be spread over several days. All MPs can suggest amendments to the bill or new clauses, which is parts that they think should be added. The report stage is normally followed immediately by debate on the bill's third reading. The third reading in the House of Commons. Third reading is the final chance for the Commons to debate the contents of the bill. It usually takes place immediately after the report stage as the next item of business on the same day. Debate on the bill is usually short and limited to what is actually in the bill, rather than as at second reading what might have been included. Amendments and proposals for change cannot be made to a bill at a third reading in the Commons. At the end of the debate, the House votes on whether to approve the third reading of the bill. If the bill started in the Commons, it goes to the House of Lords for its first reading. If the bill started in the Lords, it returns to the House of Lords for consideration of any amendments the Commons has made. So this is the first reading in the House of Lords. So the first reading in the House of Lords is the first stage of the bill's passage through the House of Lords, usually a formality. It takes place without debate. The first reading of a bill can take place at any time in a parliamentary session. The long title indicating the content of the bill is read out by the member of the Lords in charge of the bill. Once formally introduced, the bill is printed. The next stage is the second stage, the first opportunity for the members of the Lords to debate the main principles and purposes of the bills. Second reading in the Lords. Second reading is the first opportunity for members of the Lords to debate the key principles and main purpose of a bill, and to flag up any concerns or specific areas where they think amendments, any sort of changes are needed. Before a second reading debate takes place, members who would like to speak add their name to a list, the speakers list. The government minister, spokesperson, or a member of the Lords responsible for the bill opens the second reading debate. Any member can speak during the second reading. This stage can indicate those members particularly interested in a bill or specific aspect of it, and those who are most likely to be involved in suggesting changes at a later stages. Second reading debates usually last for a few hours, but can sometimes stretch over a couple of days. After the second reading, the bill goes to the committee stage, where detailed line-by-line examination and discussion of amendments takes place. So the committee stage at the Lords. The committee stage involves detailed line-by-line examination, as mentioned earlier, of the separate parts, such as the clauses and schedules of the bill. Starting from the front of the bill, members work through to the end. Any member of the Lords can take part. Usually starting about 2 weeks after the second reading debate, committee stage generally lasts up to 8 days, but can go on for longer. Before committee stage begins, amendments and any changes are gathered together and placed in order, then published in the marshalled list. Updated lists are produced before the start of each day of the committee stage. So the committee stage continued at the Lords. During the committee stage, every clause of the bill has to be agreed, and votes on any amendments can take place. All suggested amendments have to be considered. If a member wishes and members can discuss an issue for as long as they want, the government cannot restrict the subjects under discussion or impose a time limit. This is a key point of difference with procedure in the House of Commons. If the bill has been amended, it is reprinted with all the agreed amendments. At the end of the committee stage, the bill moves on to the report stage for further scrutiny. The report stage, Lords. Report stage gives all members of the Lords a further opportunity to examine and make amendments, which are any sort of changes to a bill. It usually starts 14 days after committee stage has concluded and can be spread over several days. but is generally shorter than the committee stage. Before report stage begins, amendments are gathered together and placed in order, then published in the marshalled list. Updated lists are produced before the start of each day of the committee stage. During the report stage, detailed examination of the bill continues. Any member of the Lords can take part and votes on any amendments may take place. After the report stage, the bill is reprinted to include all agreed amendments. The bill then moves to a third reading, a further chance for the Lords to discuss and amend the bill as it nears conclusion. If the bill is amended, it is reprinted to include all the agreed amendments, and the bill moves to the third reading, which is the final chance for the Lords to amend the bill. The third reading in the Lords. Third reading in the Lords is the chance for members to tidy up a bill, concentrating on making sure the eventual law is effective and workable, without any loopholes. Before third reading, amendments changes are gathered together and placed in order, then published in the marshalled list. Unlike the House of Commons, amendments can be made at third reading in the House of Lords, provided the issue has not been fully considered and voted on during either committee or report stage. Third reading continued. Amendments at third reading are often used to clarify specific parts of the bill and to allow the government to make good any promises or changes they made at earlier stages of the passage of the bill. If the bill is started in the Lords, it goes to the House of Commons for its first reading. The Commons reprints the bill with the Lords' amendments. If the bill began in the Commons, it is sent back after third reading in the Lords for consideration of Lords' amendments, or if they have no amendments in the Lords, is sent back to the monarch for royal assent. Consideration of amendments. When a bill has been passed through third reading in both houses, it is returned to the first house where it started. For the second house's amendments, proposals for change to be considered. Both houses must agree on the exact wording of the bill. There is no set time period between the third reading of a bill and consideration of any Commons or Lords amendments. If the Commons makes amendments to the bill, the Lords must consider them and either agree or disagree to their amendments or make alternative proposals. If the Lords disagrees with any of Commons amendments or makes alternative proposals, then the bill is sent back to the Commons. A bill may go back and forth between each house, which is called ping pong, until both houses reach an agreement. Once the Commons and Lords agree on the final version of the bill, it can receive royal assent and become an Act of Parliament. The proposals of a bill now become law. In exceptional circumstances, when the two houses do not reach agreement, the bill falls. If certain conditions are met, the Commons can use the Parliament Acts to pass the bill without consent of the Lords in the following session. Royal assent. And this is the final stage. When a bill has been completed, all its parliamentary stages in both houses, it must have royal assent before it can become an Act of Parliament, which is a law. Royal assent is the monarch's agreement to make the bill into an act and its formality. There is no set time period between the consideration of amendments to the bill and royal assent. It can even be a matter of minutes after ping pong is complete. When royal assent has been given to a bill, the announcement is usually made in both houses at a suitable break in each house's proceedings by the Lord Speaker in the Lords and the Speaker in the House of Commons. Prorogation, the formal end of a parliamentary year. Black Rod interrupts the proceedings of the Commons and summons MPs to the Lords' Chamber to hear the Lords Commissioners announce royal assent for each bill. The legislation within the bill may commence immediately after a set of period or only after a commencement order by a government minister. A commencement order is designed to bring into force the whole or part of an Act of Parliament at a day later than the day of royal assent. If there is no commencement order, the Act will come into force from midnight at the start of the day of the royal assent. The practical implementation of an act is the responsibility of the appropriate government department, not Parliament. When the bill is started in the House of Lords, it undergoes the following steps as discussed in earlier slides. So first reading, which is the Lords, slide number 12. Second reading, Lords, slide number 13. Committee stage, Lords, slide number 14 to 15. Report stage, the Lords, slide number 16. Third reading, Lords, slide number 17 to 18. First reading in the Commons, slide number 6. Second reading in the Commons, slide number 7. Committee stage in the Commons, slide number 8 to 9. Report stage in the Commons, slide number 10. Third reading in the Commons, slide number 11. Consideration of amendments, slide number 19 to 20. And then royal assent, slide number 21 to 22. Now we've looked at the procedure for how a bill is to be passed before it becomes a law, and went through the different stages in the House of Commons and House of Lords. Now we're looking at 1.2 is to differentiate between criminal and civil law. So introduction to civil law. Civil law is a place to ensure that individuals are protected from one another and the state. The rights and responsibility of individuals are laid out in a civil law through both legislation and through court rulings, which are referred to as common law. In some instances, an offence will fall within both criminal and civil law. For example, drivers maintain a duty of care to each other, and if only drives recklessly and causes an accident in which someone else is injured, a civil claim can be brought against the offender for negligence, as well as a criminal prosecution. Civil law is quite different from criminal law, as we mentioned earlier. It's concerned with the rights and property of individual or people or organisation, which may not always be protected by criminal laws. Civil law disputes between individuals and organisations and is often involves compensation being awarded. Considerations made by the court in a civil law case. There are requirements for certain considerations to be satisfied before civil law action can be taken. For negligence to be established in a civil claim, the claimant must demonstrate the following were present. A duty of care was owed to the defendant. There was a breach of this duty of care. The breach of duty caused an injury, damage, or loss to another person. And then the standard of proof lies within the claimant, though the demands are less than those in criminal trial, as the claimant is only required to prove their case on the balance of probability and to achieve a successful result. In civil law, the penalties and remedies. So public law, you have public law is a type of civil law which refers to the state's duty to protect an individual, as we mentioned earlier, their rights from other people or organisations. An example is that the state is authorised to impose various orders against domestic abuse offenders, orders that are issued to protect the local community, or vulnerable people, and antisocial behaviour orders such as ASBOs. If these orders are breached, the offender can be held accountable and can suffer a criminal prosecution. The penalties and remedies in civil law. There are a number of remedies that can be issued under civil law, including damages and compensation, as mentioned earlier, orders for specific actions and injunctions. The court will make the decision on appropriate remedy based on the particulars of the case and the action being sought by the claimant. Examples of civil law cases include things like family disputes, such as divorce, dissolution of civil partnership, children's issues, and childcare arrangements. And there's also other examples such as personal injury claims, which has road traffic accident, slips and trips, breach of contract, such as where as cases where money is unpaid or a contract isn't honoured. Employment law, for example, where employee suffers discrimination. So then we go on to what criminal law is, introduction to criminal law. So criminal law serves to ensure that that each person in the United Kingdom understands what is considered to be acceptable behaviour and conduct. The majority of criminal law is set out in numerous acts of Parliament, such as stealing, as outlined in the Theft Act, and others such as the Criminal Damage Act and the Offences Against the Person Act. When a person has breached criminal law, they are considered to have wronged society. They may be liable for criminal action and prosecution from the state. Following an investigation or a trial, an offender may be made accountable through prosecution, which can include penalties of imprisonment, community orders, or fines. How is criminal law cases processed? Criminal proceedings are begun through police action and supported through the Crown Prosecution Service, the CPS. These cases will be brought in the name of the Crown. The vast majority of criminal cases begin in the Magistrates' Court. If appropriate, the case will be brought before a judge in the Magistrates' Court and defendant will be tried there. But if the case is of more serious nature, the offender will be brought before judge and jury at the Crown Court. Considerations made by the court in criminal law cases. Criminal liability normally considers a mental element known as mens rea and a physical element that is referred to as actus reus of the crime. Mens rea may refer to the defendant's intention, negligence, or recklessness with that knowledge. As an example, a case of theft will include the mens rea of dishonest intention and the actus reus of carrying out the theft. Once this has been established, the defendant can be convicted. The physical element of the offence does not require the defendant actually physically moves in order to carry out the crime. For instance, for the offence of fraud, the mental element would be dishonesty and the physical element would be the defendant's false representation. In some criminal law cases, such as traffic accidents or environmental crimes, it is not necessary for a mental element to be established. This means that the premeditation or intent are not necessary requirements in order for the defendant to be convicted. These types of offences are referred to as strict liability offences. One of the most important aspects of UK criminal law is that a defendant is presumed to be innocent until they are proved to be guilty. It is that enables us to benefit from a fairer judicial system. In criminal proceedings, the criminal standard of proof is adopted, and this means that the prosecution must, beyond a reasonable doubt, prove that the defendant is guilty. If any reasonable doubt is present, the jury or magistrates are obliged to acquit the defendant. So looking at a comparison between civil and criminal law, the definition is civil law deals with the disputes between individuals, organisations, or between the two in which compensation is awarded. For criminal law, the definition is criminal law is a body of law that deals with the crime and the legal punishment of criminal offences. The purpose of civil law is to deal with the disputes between individuals, organisations, or between the two in which compensation is awarded to the victim. In criminal law, is to maintain the stability of the state and society by punishing offenders and deterring them and others from offending. The jury opinion in civil cases is that the opinion of the jury may not have to be unanimous. Laws vary by state and country. Juries are present almost exclusively in criminal cases, virtually never involved in civil actions. Judges ensure that the law prevails over passion. In criminal cases, the jury must agree unanimously before a defendant is convicted. The cases are filed by private party, and for criminal cases by government. The decision, the defendant can be liable or not liable, the judge decides in civil cases. In criminal cases, the defendant is convicted if they're guilty and acquitted if not guilty, and the jury decides this. And then standard of proof is the preponderance of evidence. Claimant must produce evidence beyond the balance of probabilities in civil cases. In criminal cases, it's beyond a reasonable doubt. The burden of proof, the claimant must give proof. However, the burden may shift to the defendant in situations of res ipsa loquita, as the thing speaks for itself in civil cases, and the burden of proof in criminal cases that innocent until proven guilty. The prosecution must prove defendant is guilty. The type of punishment in civil cases is compensation, which is usually financial, for injuries or damages, or an injunction in nuisance. And for criminal cases, a guilty defendant subject to custodial sentence, which is imprisonment or non-custodial punishment, fines or community service. In exceptional circumstances, the death penalty. Examples is for civil cases, landlord and tenant disputes, divorce proceedings, child custody proceedings, property disputes, and personal injury. And for criminal cases, theft, assault, robbery, trafficking in controlled substances, murder, and the list can go on, drugs, money laundering. Appeals for civil cases, either party claimant or defendant can appeal a court's decision, and in criminal cases only the defendant may appeal at a court's verdict. The prosecution is not allowed to appeal. And the commencements of proceedings is for civil cases, state, people, prosecution by summons or indictment, and by for criminal cases it's by way of pleadings, representatives of the state, prosecutor and attorney general. The fundamental difference between civil and criminal law is two different objects which law seeks to pursue, redress or punishment. In other words, criminal law seeks to punish for an offence and civil law seeks to achieve a remedy. For example, as we mentioned earlier, any sort of compensation for the injured party. And when we look at whether a person, as we mentioned a little bit earlier, whether a person can face both criminal and civil action for a crime, and the simple answer to this is yes, and it happens quite frequently. The Crown prosecution will prosecute a person in a criminal case, and then a wronged person, for example, the victim of a robbery or assault, may choose to bring a civil action against the person too. The person may be found innocent in the criminal court but lose civil case in order to pay damages or compensation to the injured party. Now we're going to go on to looking at the differentiating between public and private law, which is 1.3. So, introduction to public law. Public law administers the relationship between the government and individuals. It comprises of standards governing the relationship between various branches of the government and rules administrating the relationship between the government and the people of or private bodies. So in general terms, public law deals with the issues that affect the general public or society as a whole. Some laws that fall under the public law umbrella, as we've mentioned there, can be things like constitutional law, and this is related to the constitution of the country, is especially concerned with the three main branches of the government, i.e. the legislature, the judiciary and the executive. Administrative law, and this is the law governing the functions of the government and the role it plays for its citizens. This area of law regulates such as trade, economy, public service, environmental protection, and taxation. And then we've got criminal law, and this is a law that's concerned with the punishment of offenders. We've got other examples as well, which are things like municipal law, international law, that may be part of, that come under the public law umbrella. So, significance of public law. The public law sets up the powers and obligations of governments and categorises the rights and obligations of the people to governments. It is believed that public law is an area intended to encourage and promote the common good for the benefit of the community. Generally, public law tries to ensure the public interests of the general population, since the abusing the public law would affect the community. The sanctions imposed for violations are considered to be severe in nature. For instance, the sanctions under the criminal law could vary from fines, imprisonment to death penalty. How do public bodies derive their legal authority? Generally, public bodies and authorities derive their power to make decisions and for action or inaction of them from the Acts of Parliament. These are often called statutory powers and obligations and can be found under one or more of the below listed sources. Legislative enactments of Parliament, gazette orders, rules and regulations enacted by ministers under the authority granted by Parliament, regional community law, which are directions and regulations made by the authorised legislative bodies of the regional organisation, public policy, which are the rules and procedures of a government. It holds no citizen can do anything that would be harmful to the public as stated by the government. There are remedies under public law, which are what are the public wrongs. Public authorities need to act according to the public law principles. This implies that they have to follow some of the few principles. Function legitimately, public authorities must follow the law. They must not misuse their powers or do anything which are not legally authorized to do. They must act rationally and reasonably, and they must follow just procedures. Remedies under public law. One of the most common remedies available under the public law is the judicial review, where the judges appraise the legality of the actions and resolutions of public bodies. In addition, other methods of settling grievances include appeals, inquiries, private law actions, internal complaints procedures, and the Parliamentary Commissioner for Administration, which is the Ombudsman. So other public body functions include local authorities deciding whether or not to provide accommodation, the DWP deciding or not to award someone welfare benefits, government ministers deciding to lay regulations that determine who can access legal aid, and local authorities deciding whether to grant planning permission or not for someone. Then we go on to the next element of it, which is private law. So, introduction to private law. The private law is the body of law which governs the relationship between private and individuals. Private law categorizes the rights and obligations of the people and private bodies in the relationship among the IFA. It covers various key areas of such as contracts, property, equity and trust, tort, succession, and family law. The private law ensures the freedom of the people to pursue their aims and goals. Here, the legal relations enable the parties to act freely in their private capacities of private individuals. The private law tries to secure just private interests, freedom of the individuals in the community. Most of the remedies in private law are pecuniary, monetary nature. The party who has infringed the law needs to pay some amount of cash to the injured party and not to the state as determined by the court. So we've got law above, we've got public law, which deals with constitutional, administrative and criminal, and private or civil law, which deals with contract, tort, property, trusts and family. Features of private law. The private law is categorized by the evidential, procedural and doctrinal guidelines that oversee any issue between particular parties, claimant and the defendant. The claimant, the party who claims to have been wronged, brings an action against the defendant who is alleged to have committed a wrong. If the court discovers that the defendant is in charge of wronging the claimant, the defendant is obliged to make good for the claimant's damage or harm, generally by providing a pecuniary compensation or restitution. In private law, the claimant is not ready to bring an action against anybody other than the defendant. Thus, private law forms a relationship between the claimant and defendant for having perpetually wronged the other. Features of private law. The claimant and defendant under the private law can be private individuals, business organizations, or any party acting in the capacity of a private person, and such disputes must have occurred only between the claimant and the defendant, where they could either conform or repudiate the alleged wrongdoing. Thus, the state's role in the area of private law is limited to providing a systematic mechanism for resolving disputes between the claimant and the defendant. Private law remedies and sanctions. So, restitution in integrum restitutia, the party alleged to have breached the law will have to restore any matter to the state condition as of the breach of law that had never happened. For example, if the supplier of certain goods hasn't received the payment for a buyer on a specified date, as stated in their contract, the court might order the buyer to return the goods bought to the supplier since the buyer had breached the contract. The damages and compensation, so an amount determined by the court will have to be paid to the other in order to compensate for the actual damage or loss of profit by the injured party. Returning enrichment. Where the party has been breached, the law has benefited unjustly, it is known as unjust enrichment. The court will determine the amount for unjust enrichment to be paid as compensation. Specific performance. At times, the private law may recommend a remedy to be of a non-pecuniary nature. In these circumstances, it's not the payment of the money that is required, but the other party ought to do or give up something, i.e. specific performance. For example, if the supply of certain goods had breached the contract to deliver X, they will be ordered by the court to honour the contract, have the goods delivered to the buyer. Examples of private law. Our common examples of private law can be found in organisations and employments. For example, the rules of behaviour established by an employer. This can be in the form of the day-to-day rules, such as no smoking at headquarters, no creation of hostile work environment, etc. The penalties for breaking these rules can range from an oral reprimand to being removed from the organisation. Another example, smoking indoors is a classic example of public against private law regulation. As a public law, smoking indoors is prohibited in the UK. However, groups of citizens join together to create a mutual agreement between property owners, which the government has no regulation over. Covered by this private law, those within this property, often a pub, are then allowed to smoke indoors. There are some subdivisions of law which fall under the umbrella of private law, which are contract, as we mentioned earlier, tort, property, labour law, commercial law, corporations and competition. So these are some of the examples. Also, when we look at the issue of the difference between each one, we mentioned it, some differences may already have become apparent after defining them, but it highlights the difference. Generally, these two titles are purely for categorization, for grouping laws within the legal system. Public law, as we mentioned earlier, is the regulation of the legal system itself rather than the regulation of individuals. Simply, the main difference between public law and private law is whether the act or acts affect society as a whole or an issue between two or more people. So when we look at the distinction between public and private law, we can sometimes a distinction that's blurred where some acts may arguably violate both kinds of law at the same time. Certain acts that are said to be offences against society may be considered sufficiently public in nature or to be classified as crimes. Many property crimes involve the infliction of private harm. Such private offences may therefore be classed as torts as well as crimes. These are some of the references that we've used in today's session, which is some of the references: Review of Economic Dynamics by Adelini, Public Law, European Law by Anthony G., the Ashworth Principles of Criminal Law. We've also looked at Interpreting Precedents, The Rule of Law by Bingham, Derbyshire English Legal System, Elliot Quinn English Legal System. So these are some of the resources that you can use, but also you need to be looking at the resources. So we've finished the session now on Learning Outcome 1, and we will be concluding on to Learning Outcome 2 in the next session. But you need to go on to Moodle to get any sort of additional resources, any case law that will help you for the Learning Outcome 1, and also look at any sort of journal articles, anything on Moodle that will help you towards achieving your mark when you are doing Learning Outcome 1. Thank you for attending today's session.